Assalamualaikum. My name is Syamila Binti Nazri with metric number 281439. Now I'm going to talk about the definition for this topic. Before that, Consumer Protection Act 1999 was established on 15th of November 1999. The aim is to give better protection for consumers. According to Section 3 of the Act, manufacturer means a person who carries on a business of assembling, producing or processing goods, and includes first, any person who holds himself out to the public as a manufacturer of the goods. Second, any person who affixes his brand or causes or permits his brand to be affixed to the good. And third, where goods are manufactured outside Malaysia and the foreign manufacturer of the goods does not have an ordinary place of business in Malaysia. Section 3 of this Act also defines the words goods, which means goods which are primarily purchased, used or consumed for personal, domestic or household purposes, and includes goods attached to or incorporated in any real or personal property, animals, vessels and vehicles, utilities, trees, plants and crops, whether on, under or attached to the land or not. However, it does not include choses in action, including negotiable instruments, shares, debentures, and money.
Moving on to the scope of the study. So, the problem that sparks our interest in the study is that there is a lot of consumers who always face injustice when issuing claims against the manufacturer under Contract Act 1950. It is because those provisions do not narrow in covering areas regarding consumers' rights if the goods received were not as expected or broken. Hence, our aim for this study is to inscribe provisions in the Consumer Protection Act 1999 regarding the consumer's right to go against the manufacturer on the ground of good and the limitation in the act that may backfire on the consumer. Next, the scope focuses on two laws, which is Consumer Protection Act and the doctrine of privity of contract, but it is not limited. In this study, we will touch on Part 7 of the Act that specifies right against manufacturer in the supply of goods if it fails to meet their implied guarantee. This study also includes the privity of contract, where the principle may not be applicable after the establishment of the Act. And last, we also include the loophole in this Act, which is Section 51, where it gives protection for the manufacturer to not be liable on goods received.
Generally, a consumer has no right to claim against the manufacturer as there was no contract between them, due to the doctrine of privity of contract. However, with the emergence of Consumer Protection Act 1999, consumers are now provided with the right to redress against manufacturers despite the absence of contract between them. This is provided under Section 50 of Consumer Protection Act, where it confers rights of redress to consumers if the manufacturer of the goods fails to comply with certain implied guarantees such as acceptable quality, description, repairs and spare parts, and express guarantee made by the manufacturer. However, there is an exception to that, whereby Section 51 of the CPA 1999 provides no right of redress against manufacturers if the failure as regard to the goods in complying with the implied guarantees is due to an act or omission made by a person other than the manufacturer and due to causes uncontrollable by human, which occurs after the goods have left the control of the manufacturer. Hence, it can be said that this exclusion clause under Section 51 appears to be unfair to the consumers as it enables the manufacturers to escape liability. Nevertheless, consumer can still claim for damages as provided under Section 52. Section 52, subsection 1 provides a consumer who has a right of redress due to the manufacturer's failure to comply with implied guarantees may claim damages from the manufacturer. Such form of damages include reduction of the price paid by the consumer or the replacement of the goods with a new one.
In the case of Ong Singhua and UMW Toyota Motor Sdn Bhd, appellant found the new vehicle to be defective and made numerous complaints to respondent, which is the Toyota, in virtue of Section 50, Paragraph C of the Consumer Protection Act. However, the trial judge found that once the hire purchase agreement came into effect with the bank, there ceased to be any contractual relationship between Ong and Toyota. In addition, in the present court, the learned judge in their finding affirmed with the decision by the previous court, which the plaintiff cannot claim to Toyota. In the next case, plaintiff bought the car from the first defendant. So in this case, as pursuant to Section 52 of the CPA 1999, the plaintiff actually made claims against the manufacturer if the plaintiff has requested the manufacturer remedy the deficiency and the manufacturer has declined or neglected to a remedy. However, in this case, the manufacturer's warranty was an express guarantee provided to the plaintiff by the first defendant that if the state of the car did not comply with the guarantee, the plaintiff would be entitled to order the first defendant to correct the failure by fixing the car or replacing it with a similar car. In addressing abolishing assumption on Section 51 of the CPA 1999, we agree that manufacturer is the only party that can monitor products that they produce. As in the case of Goldbergs and Coleman Instrument Corporation, this case demonstrates a court could place responsibility on the producer of the products because the manufacturer regulates the production process of the product itself. And the manufacturer is the best or the perfect party that must bear the burden of ensuring that an object is a fit for a specific purpose. As in the case of Gordon and M. Hardy, this case has reinforced the claim that manufacturers should be kept accountable if their products are not fit for a specific purpose.
For the analysis, the consumers indeed need more protection from the Consumer Protection Act 1999 to give them safety, provide guarantee, and also protect their rights. Section 50 and 52 of the Act already provided the rightful rights of the consumers. However, there is still a section provided in Section 51 of the Act, meaning that the consumers still not get their rightful right to against the manufacturers. Before the existence of the Act, the Malaysian law refers to Contract Act 1950. And because of this, the consumers often receive unfair treatment, and sometimes their justice cannot be served. There are 4 cases law used, and all 4 of them and 2 of them followed what had provided in Section 50 and 52 of the Consumer Protection Act, and the other 2 also give the consumers their rightful rights against the manufacturers. Thus, the court does not wholly use the sections provided in Consumer Protection Act 1999 because the consumers prefer not to bring the suit to the court. They choose to ignore it and they choose to stay quiet about it. Sometimes they blame the seller and not the manufacturers. We don't want this to happen. We want the consumers to get their rightful right. We want them to get their justice. And therefore, we urge the government to abolish Section 51 of the Act that still give manufacturers protection. We don't want this. We want the consumers to get the protection, and because this Act is mainly about the consumers. Thank you.
So, what are the conclusions from this study? Firstly, the establishment of the Consumer Protection Act 1999 has eradicated the doctrine of privity of contract. Thus, the consumers now can claim against the manufacturers for any defective goods that they have bought. Secondly, even though the aim of this act is to protect the consumer, there is still an inadequacy in this act that we can see, such as in Section 51 of the Consumer Protection Act 1999, that provides an escape door for the manufacturers to deny their liability. Thus, we can see that the Act is not used wholly and fails to serve its purpose wholly, as there is still inadequacies in this Act. What we can recommend based on this study, firstly, is to abolish Section 51 to eliminate the elements of injustice against the consumers. Secondly, a broad scope of applicability, because this act supposedly needs to provide more protection for the consumers to be used thoroughly. And lastly, we suggest for our lawmakers to make a comprehensive review against this act to secure the rights of the consumers. That's all from us. Thank you.